Hello, everyone. I'm Neville Johnson. I'm your moderator and one of the panelists. Let me tell you that this is done on behalf of the Beverly Hills Bar Association. Let me see the next screen, please. And we want you to know there's 3 levels of membership. There's a professional level, a sustainer membership, and the economy membership. You should know that it is extremely valuable to be a member of the Bar Association. I'm on the Board of Governors, and I can tell you that we're extremely committed to giving the best service and education possible. So please check out the Beverly Hills Bar Association for membership if you haven't. This seminar is brought to you by JAMS. I'm sure you all know what JAMS is. They are one of the top, if not the top, mediation and arbitration administrators and entities across the United States. And their slogan is, JAM doesn't just resolve disputes, we solve problems. So thank you very much to JAMS. We very much appreciate it. With that, I will make the introductions. First, I'll just say this is Scott Edel, who is chair of the entertainment department at Loeb, which is a national law firm, and he is one of the top practitioners in the field of entertainment law, and we're thrilled to have him. Starting off will be David Helfant, who is with the law offices of David Helfant. For 3 or 4 decades, he has been one of the preeminent attorneys practicing, especially in the music field, and has a lot to offer overall. I, Neville Johnson, am the founding partner of Johnson & Johnson in Beverly Hills. We are entertainment attorneys predominantly. We do a lot of work in litigation, including class actions against the movie studios and record companies, and also some transactional work. With that, take it away, David. Oh, one other thing. You can send questions via the chat icon, and we will get to them at the end of the session today, I expect. Okay, with that, David, take it.
Okay. Hi, how's everybody doing? I know we're going through some difficult times. I hope everybody's safe and healthy. My conversation today will focus on, to a large extent, the impact of how the pandemic has changed the landscape for practicing law, and in particular, my emphasis will be more in the music area. That being said, I do film and TV work as well, and I will say that, with the pandemic hitting, production has essentially been shut down. There are protocols that are currently being negotiated with producers, the studios, and the unions to try and come up with safeguards to protect people in the event that production goes into effect while the pandemic is still in shutdown or some version of shutdown. As it relates to music, the single biggest impact on the music industry has been the inability for any artist to tour live. Now, for many decades, the sale of recorded music and publishing revenues were the primary source of revenues for musicians. As the sale of recorded music went down over the last 5 to 10 years, and streaming has now become more prominent than downloading or purchasing, the landscape has changed dramatically, and as a result, most musicians now rely heavily upon their touring income to sustain their lifestyle and pay their bills. So obviously, with the inability to tour, it's created tremendous havoc for most musicians in the industry. What has replaced touring is virtual and online concerts. At the end of the day, I will always say that, and this is my Ahmet Ertegun and Clive Davis speech, that it's always going to be about the song. So I don't care if you're in a pandemic or you're in the most fruitful time in the music industry, if you don't have great material, you're in trouble to begin with. But that being said, I think what a lot of people are asking me these days, are deals even going down? Are record companies making deals, or publishers making deals? So I have found, because I'm in the middle of several negotiations right now, that record companies, whether they're majors or independents, are being much more cautious about entering into deals, and in particular, the size of the advances. You know, not knowing what the revenue stream is going to be in the next 1 to 3 years, record companies have taken a little bit more of a conservative approach. There has been a trend over the last several years, which annoys me to no end, but it's part of the reality of now being more in the digital world. It used to be that when I was shopping for a record deal, it was strictly about the music and the team that was involved with the artist, the agent, the manager, the accountant. And now much of that has been replaced with, yeah, I know your music is good, but how many friends do you have on Facebook? What's your engagement on social media? When you post something, do you get 100 people or you get 12,000 people? And do they talk to you? And many record companies are now looking at the data rather than strictly the music to determine whether there is a fan base for you. And in the event that they determine that the music is good, but you haven't engaged in an online community in a meaningful way, they will say to you, either you put the music out yourself and prove to us that there's a demand in the marketplace, or you're not ready, you know, keep developing your brand and come back to us in a year or two. You know, for many artists, the most difficult question is, do I even need a record company? You know, in the days where record companies controlled the pipeline, you had to have a label to get, you know, on in retail outlets. Now, with DSPs and e-tail, all of a sudden the pipeline is open to everyone. But that being said, there's so many people that are releasing music independently without the proper marketing budget and potentially a team of people to help you. You're still going to have a hard time, you know, creating momentum for your brand. So what I always tell people is, even if you're going to release your music independently, you should think about several different elements to assist you. One, having a good publicist is always critical. You need to make sure that people are aware that your new music has just come out. Two, I would usually suggest to people that they hire a social media company to help them develop their online presence. And what I would typically suggest to people is that you work out a regular regime for posting. So you figure out how many times a week you want to post, what the messaging for the posting should be as it relates to building your brand and creating awareness for your music. And then the time of day that you post, because social media companies will give you advice and counsel about the best and most potent time for you to post based on your demographics, kind of music you're doing, and the target demo that you're trying to reach. I also recommend to people looking at the possibility of an independent radio team, which can sometimes become expensive, but if you're doing it yourself, it's not a bad idea to bring on some radio promo guys that can really help you to get your songs added to radio playlists as well as Spotify and Apple playlists, which are now becoming as important or more important in the big scheme of building your brand. Lastly, there are people that do what I call virtual record company services or label services. There are companies that will, for a fee and a percentage of the sale of the records, help you to create and integrate a marketing plan into your launch so that you tie in radio, social media, retail, placements, playlists, and that label services person will usually be the quarterback or the quarterback with your manager to assist in putting the team together. As it relates to live touring, which I mentioned earlier, live concerts have now been replaced exclusively for the moment with virtual online concerts. And there's a number of software that you can look at for creating the content. Some people do it live. Some people pre-record their shows and then post as if it's live and then take Q&A afterwards. And then some people are doing these virtual concerts free so that they could build their online following and for promotional purposes. And then there are many companies like Stage It that will actually create the virtual concert for you in exchange for you selling tickets. And you can create a multi-tiered platform for tickets, or you can do one price. What some people do in the virtual space now is they'll create, let's say, a $5 or a $10 ticket if you want to see the show. Maybe it's $15 if you want to watch the show now, but you have the ability to stream it on demand for the next 2 to 5 days. And then a third tier, which allows you into a chat room at the end of the virtual concert, where you're basically buying a meet and greet with the artist. And then some people will also throw in some signed merch, maybe a picture, maybe a CD, maybe a t-shirt. And so that's how, our recording artists and touring artists are now monetizing these virtual shows. Lastly, some of the online venues are also creating what I call tip jars, where you might have a 2 or a 3 tier ticket. But in addition to that, if you have an Uber fan that just loves what you're doing and they want to give you $100 just because they want to support you in these difficult times, the tip jar will allow them to give you additional money at whatever they determine is appropriate. One of the big conversations right now is, well, how long will this situation go on? And the truth of the matter is nobody really knows. What I've experienced for the shows that I had booked for my recording artists going out on the road, everything's basically been pushed back, starting with spring or summer of 2021. And some people are even pushing back as much as the beginning of 2022. Part of the reason why it's important to plant the flag in the sand now and get your shows booked, even though it feels like it's miles and miles away, is so many people are going to be vying for the same spots in venues, whether they be little clubs or bigger venues. If you don't secure and lock in your dates now for 2021 and 2022, there's a good likelihood that you won't be able to properly schedule your tour, because in order to be able to properly route the tour, you may not have the flexibility of determining where you want to go and in consecutive dates. So if you don't start booking shows now, you may be put in a very difficult situation down the line. As it relates to publishing deals, I'm still doing publishing deals. Some people gravitate more to the co-publishing situation, which is basically where the songwriter will sell a portion of the publishing, oftentimes 50% of the publisher's share of the publishing, and grant that publisher exclusive administration rights during the term of the agreement in exchange for a significant or a substantial advance. Other people don't want to divest themselves of their copyrights, but they want a team on a worldwide basis to collect and receive their money for them. So they enter into an administration agreement for typically anywhere from 8 to 20% administration fee. Oftentimes there's no advance or a much smaller advance, but the benefit of doing the administration deal is you're not divesting yourself of your copyright. So at the end of the term, the administration rights would typically revert back to you, and then you could make another deal. You can collect your money yourself, or you can then decide that you've now built up your catalog to a place where doing a co-publishing deal makes more sense because you have more traction for your material in the marketplace, And now it makes sense to do the co-publishing deal because you can get more money for your content. Sync opportunities are still important in building your brand, although I will say that, you know, I represent a lot of music libraries, and trailer houses are not doing the volume of business they used to be. Obviously, a large portion of music for trailers was to roll out motion pictures in theaters. And because that's not happening anymore, the volume of sync licenses in the trailer world has gone down significantly. There's still the ability to procure syncs, but they're a little more limited than they used to be, let's say a year or two ago. And then I'm going to wrap up my initial segment by talking a little bit about AB5. So in January of this year, the legislature in Sacramento passed a bill, Assembly Bill 5. The intent and purpose of the bill initially was to regulate Uber and Lyft drivers. So for the sake of discussion, the legislature was concerned that if somebody got into an Uber or a Lyft and there was an accident and they sued the driver of the Lyft, and the driver said, hey, you know, I don't have any money and I don't have insurance, and so, you know, do whatever you want. So they wanted to make sure that the Uber and Lyft companies had some liability. And so they determined, for purposes of this bill, that rather than Uber and Lyft drivers being considered independent contractors, and therefore Uber and Lyft wouldn't be liable or responsible in any fashion, they determined that because Uber and Lyft actually controls the way that they do business, how they pick up people, sending out opportunities, they really were an employer and these drivers were employees. So this bill was passed in January 1. They did not target the group of people that they were intending to be governed by the bill. And as a result, it had very broad sweeping implications in you know, every industry. So as it relates to the recording industry and touring, people were concerned that, you know, creating an employer-employee situation would actually be detrimental. So Manav Phelps was instrumental in going to Sacramento and getting a carve-out for AB5 as it relates to songwriters and musicians. So now they're no longer deemed to be employees. What a lot of people were concerned with, if I was a recording artist and I was making a small indie record and I was hiring a drummer to play drums, and he said, hey man, you're my buddy, I'll do it for $100 in cash, just give me the money. AB5 would have prevented musicians from hiring their friends and treating them as independent contractors. Sacramento recognized the broad sweeping implications of AB5 and agreed to modify the class of people that it was applicable to, and did a carve out for musicians and songwriters. One of the issues that's come up for me recently, and Scott's firm is involved with this issue, is how is AB5 impacted on music supervisors? So music supervisors will typically secure music for the producer or the director of the film. They're not typically deemed to be employees for purposes of engagement, even though they take all of their directives from the production company. And so there's a question in the marketplace, are music supervisors deemed to be independent contractors or employees? You know, typically music supervisors were treated as 1099 engagements, and they would either go through a loan out or they would be treated as independent contractors. So there was a gray area there about music supervisors, and it probably will resolve itself at some point in the near future. But one of the things that you have to ask yourself is, when you're making a deal in the industry right now, what are the implications of AB5? So I recently did a deal for a producer that was being hired by a recording studio to be an in-house producer. They wanted to hire the producer as an independent contractor, and I said, no, they have to be employees. AB5 applies, and then you have to, guarantee them a certain amount of money if you're, deeming them to be exclusive employees. So the AB5 is a really important issue for you to consider every time you're thinking about a deal for a client. And obviously there'll be clarifications over time. It's still ambiguous because there haven't been any cases that have been decided yet, construing the implications and scope of AB5. But it's a very, very important issue for everybody to focus on. Scott, you're up.
Thanks, David. Yeah, and AB5 wasn't one of my topics, but you're absolutely right, and it does have implications for film and television engagements, including where individuals are using loan-out companies, and where they're not using a loan-out company, their relationship with the studio would be employer-employee, and whether AB5 calls into question whether the loan-out structure can be used. So far, the industry, there hasn't been any case law yet. Certainly, the unions have come out strongly suggesting that AB5 shouldn't impact their members' ability to use loan-out structures, even when the status of their engagement is as an employer and employee. But it was a very hot topic until early March when COVID hit, and it's been less a topic of discussion, but no less important, and something that we've yet to hear the end of. And so it is, you're right in advising that you do have to take that into consideration as you are engaging new, either representing an individual or representing a company hiring an individual.
One of the things you were just mentioning, the implication of the pandemic on AB5, and I think it's actually put a spotlight on this issue in a greater way, because for people who are no longer employed on a regular basis, the issue of benefits, unemployment, workman's comp, and all those related issues now become even more relevant to people because they can't make money.
Right.
Yeah.
Yeah. It's interesting. So first of all, I just wanted to spend a minute talking about practicing entertainment law in the time of COVID. I do want to talk about some substantive areas that we are dealing with and that we will be continuing to deal with for a long time. But I do want to just observe that, for all of us, starting in early March, it's become a new normal for all of us, and it has taken some adjustment for all of us. By and large, technology has enabled us to continue to function relatively seamlessly. Zoom, as an example, has been a great asset to practicing law, whereas before this, I don't think I really had ever done a Zoom call, and we'd done conference calls, but the technology seemed not very efficient. I think it's important as lawyers practicing privately and representing clients that we make extra efforts to reach out to our clients and spend time with them however we can. The normal course of having lunches and dinners and other opportunities to see our clients are much more challenged now, but it's even more important that we take the time to spend as much quality time as we can with our clients and to understand what they're going through. Just as an observation, I found that the actual practice of law has not been impacted that much for me. I'd say there's probably half a dozen times in the past 4 or 5 months where I thought to myself, gosh, if we could just sit down and get into a room together, we could accomplish whatever we were trying to accomplish. And not being able to do that, hindered our ability to move things, progress. But with the exception of that, by and large, I found that being able to working in this environment is still something that we can do. And frankly, I think we've all thought about this, what are the implications for the future in the post-pandemic world in terms of how we practice. And there's some profound things that we are learning through this time that will have implications for the rest of our careers, however long they are. And I'm sure the participants listening to this and watching this will be doing this for a lot longer than the three panelists. So, but I think it'll impact all of you for a long period of time. In terms of the substance, it's interesting, the film and television industry was going through some really significant changes and issues pre-pandemic. The advent of the streamers, I mean, if you look at the number of streaming services that have come online in the past 12 months, that has just completely changed the way in which we do so many of the deals we do. Is so much of a factor in everything from optioning books to hiring writers to distribution, the contingent compensation. It's really profound. And obviously, that's still the case. In addition to that, before the pandemic hit, we were dealing with the WGA and the agencies in a battle that we have not seen really to the level that it exists now in certainly my career. And that's still playing itself out. We can talk about that in a minute. So when early March hit, we were already dealing with some significant issues in how the business was operating. And in a way, pandemic, certainly in terms of the streaming business, has accentuated that and pushed that forward. In other respects, it's sort of given everyone a bit of a pause because production has been shut down while development continues at a very, very rapid pace. Production, has largely been shut down and is, hopefully slowly going to start up again. So that has given somewhat of a pause to reflect and figure out how to address some of these other issues. And it has impacted how these issues are being handled. Digging into the weeds, I think one of the issues that, in my career, I've only dealt with when there's been in any significant way, when there's been a labor dispute is force majeure provisions, which are replete in nearly every contract that we negotiate. And frankly, not enough time has been given to thinking through how those clauses are drafted. Part of the boilerplate, we just plug in a force majeure provision and don't necessarily think about it. But certainly this time period has given many of us the opportunity to have to really carefully review those provisions and determine what action or actions should be taken in light of COVID, and how does the force majeure provision operate in that circumstance. So I'll break it down into two categories: production and development. In production-related agreements, it was pretty clear what people needed to do. They needed to, issue force, if they're in production and shut down, they needed to, if a studio or production company had those rights, they needed to exercise their force majeure remedies or provisions in their contract to, reduce the amount of exposure the company had financially if they were in production or had greenlit and made pay-or-play commitments to actors and directors and whatnot. More complicated with the guilds, where negotiations were had in terms of severance and that sort of thing. We're now in a situation where we're starting to see productions start up again where they can, and we'll talk about that in a minute. And so we're looking at other parts of the force majeure provision. So many of these force majeure clauses are time limited. So you can extend for 6 months or a year, whatnot. And so you have to be thinking about that. Others give the recipient of the force majeure notice, the talent, a right to terminate after a period of time. So if a force majeure provision says, after 8 weeks, the talent can give a notice to the company to say, you either have to reinstate me or I'm terminating my contract. And so one has to, whatever side you're on those clauses, you have to be thinking about, should we send the notice that we want to terminate the contract, obviously in consult with your client and what their goals and priorities are. If you're on the company side, do you reinstate or do you allow the contract to be terminated? My own somewhat limited experience in dealing with this particular issue is that given that most of the talent committed to do the project and wants to do the talent project, and if they feel like the company's doing what they can to, and it's committed to make the movie or television series or whatever it is when they can, they haven't terminated. But, as it becomes more complicated and certain companies are able to get back into production, and we'll talk about that in a minute, and others are not, you could see projects fall apart because talent is moving on to other things. A lot of force majeure activity in the development area. So, pretty much across the board, studios issued force majeure notices on every rights contract they had. So if they were at a book or a script under option, they've sent out a force majeure notice to extend the time period within which they have to either extend the option, purchase, or lose the rights. And that's somewhat complicated in development because they can be doing that at the same time that they actually have writers writing drafts of scripts. And so you say to yourself, well, how has the pandemic actually impacted their progress to production? And that's a valid point. And so what we've seen in some instances, at least, is negotiations are had because, without an acceptance of a force majeure notice or if there's an express rejection, you could end up in a situation where the chain of title becomes clouded, right? What is the actual date by which you have to extend the option or exercise the option? If the force majeure extension is in dispute, then in theory, the time periods within which you have to option or purchase is also in dispute. And so what I found is, there are negotiations going on to say, okay, well, if we're in a writing or a reading period when a writer is doing work, then the option period continues. But after that, if the script is in and now we're trying to find a director, maybe do some location scouting, doing other things, then in that circumstance, it's really appropriate that there be an extension for force majeure. So, and I would just recommend strongly that you carefully read your provisions in that regard. Some, in the worst case, some provisions really don't call for a force majeure extension during this circumstance. The other is, there are very specific notice requirements sometimes. And sometimes those notice requirements require physical delivery of a notice. And so, I'd definitely recommend, but no one's checking their mail or maybe very delayed in receiving their mail. So you kind of have to do what's required by the contract and do what's required just as a practical measure to make sure that what you want communicated is communicated to the recipient. That kind of leads into production and the issues that we're dealing with in that regard.
Scott, can I just mention one other thing?
Please.
And this is an interesting aspect because I never really thought that we would get to this place, but typically the force majeure clause was done for the benefit of the employer or the person engaging the services of the independent contractor. Since the pandemic has hit, I have now negotiated the mutuality of the force majeure provision. So particularly as it relates, let's say, to touring, I will not confirm a tour date for a recording artist unless the force majeure provision is mutually drafted. So if the recording artist feels that it's unsafe to perform the show, they also have the right to opt out and not do the show for safety or health reasons. And so it's changed the landscape because force majeure was never typically thought of as a mutual right. And now it's been extended to both sides, which is very interesting.
Well, and that's a perfect segue to production, right? And we're dealing with that now, where you for contractual and practical reasons, you have to, if you want to restart a production, you have to have the appropriate protocols and structure that you have complete buy-in from everyone who is involved, be it individual performers, their unions, government regulators, etc. And so, what we're seeing is, on average, an increase in cost of approximately 20% of the below-the-line budget to produce in a COVID environment. And that's assuming everything goes well, right? Because there's all sorts of liability issues that are also having to be thought through. But there is a new category. Every production is going to have a COVID coordinator. A person or persons whose responsibility is to make sure that you create the right set of protocols and the right environment in which those protocols can be followed. And a number of productions are looking at how the baseball and basketball, Major League Baseball and basketball is at least slowly starting up again in terms of the concept of a bubble and how well that will work. And that's going to be a strategy that's used. But you need to be, again, careful in terms of reading pre-existing contracts that may not have adequately addressed COVID-related issues. And as you're drafting new contracts, to think through the insurance provisions, the indemnity provisions, the representations and warranties, all of those in the present environment require really careful thought in terms of how they're drafted. Poorly drafted releases of liability for COVID-related illnesses, are really not going to be enforced very well. The guilds have taken the position that any kind of waivers of that sort, something that have to be bargained with them over. And so you have guild and union issues that you have to be really careful about. In terms of the independents versus the majors, in terms of getting back into production, it's going to be much more difficult for independent companies that are more reliant on project-related or project-specific insurance policies and completion bonds than it will be for the studios. So it's virtually impossible right now to get a completion bond to cover anything that's COVID-related. If you're out on the insurance market, it's also almost impossible to get any insurance coverage for a COVID claim. Some studios have annual company-wide policies that were written pre-COVID, and so they have insurance. A lot of them don't. The studios tend not to need completion bonds. They self-bond, and so they're at an advantage. So it will be more difficult, at least in the short term, for independent companies to get their movies up and running and television series up and running than it will for the majors, which is unfortunate. But and there are some strategies. For instance, the province of Quebec has said it will provide government backing for insurance policies. And so I think there are, going to be solutions to this issue, but they're not quite sorted out yet, and that's proving to make it difficult for independent clients to get movies and television series made. The other thing I wanted to talk about briefly, and definitely want to answer questions you have about it, but the movies that were completed, or television series that were completed, more movies that had intended to be released theatrically, now that movie theaters are shut, basically, and there's no viable theatrical release plan, a number of them, Greyhound as an example, have gone directly to streaming, and that hastens a trend that we've seen for sure, which has major implications for everything that we do. one of the most important areas is how we structure contingent compensation arrangements for clients. And this was already changing rapidly before the pandemic, but now as more and more movies are in a situation where producers are trying to keep their options open, even when they're not necessarily making films for the streamers directly and in advance, they're nearly always they're now trying to make sure that they have the optionality to do one or the other. So that gets very complicated in terms of how to structure many aspects of the deal, but probably most importantly, the contingent compensation structures. And so, a lot of thought has to be given to whether you negotiate alternate back-end deals. So you have a traditional back-end, adjusted gross, net profits, what have you, for movies that have a more traditional release pattern, and then a different structure where they don't, where the studio elects to take it directly to a streamer and sell it on a worldwide exclusive basis. And what we're starting to see now is alternative back-end deal structures, where there's one traditional one and then more of a buyout premium in lieu of any contingent compensation. And so as you're representing the talent, you have to be very careful about those structures and figure out, what are you giving up, one versus the other? What is the underlying distribution arrangements that are going to implicate the back end that you're agreeing to? And if you're a lawyer helping a producer put together a project, it's essential that you not create structures that make it so that you have to go back to parties after the fact to renegotiate deal terms, because instead of going out theatrically, you now want to go out. You want to sell directly to a streamer. So we are now seeing a lot of negotiations where there is sort of a dual track. There's different back ends that negotiate. Television's a bit different in that regard. There's still very much the use of we call the modified adjusted gross receipts definition, MAGR, is still the dominant definition used both in the streaming and non-streaming world, although you're now seeing with the streamers, a shift away from that to sort of bonus structure based on number of episodes produced. So it's sort of a buyout that increases over time as more and more episodes are produced. But the studios are still using the MAGR definition when they are producing for the streamers. And so, again, when you're representing talent, you want to try to understand what kind of deal the studio would be making with a streamer to be able to calculate, in rough terms at least, what the proposed MAGR definition you're being given would result in, and under what circumstances. So it's requiring an extra level of diligence at the upfront in calculating in negotiating these definitions to figure out what they actually mean in different distribution structures. I'll wrap up just quickly on one last topic, which is the WGA situation, which we spoke of earlier. The most recent news is that United Talent Agency has signed a settlement agreement with the WGA. It was a win for both parties for sure, and it contains, as do many of the agreements reached with smaller agencies, a favored nations clause. So that the three agencies that have not settled are the three biggest: CAA, WME, and ICM. And there's antitrust litigation that is ongoing, and most recent rulings have really been in the agency's favor. So it appears those agencies, for the moment, are going to play out the litigation, I think the next hearing or next decision date is sometime in September. And so this issue is not resolved. Again, just by way of reminder, if people don't know, there are really two issues at stake here. One is the use of packages, packaging commissions, and the other is affiliated productions. And so, the settlements have generally been where agencies have agreed that they will cease packaging by a certain date and under certain circumstances. The most important circumstance is that the agencies are able to effect a similar agreement with the other three agencies. And that remains, to be seen. I think the UTA agreement doesn't really take into force the no packaging rule for 2 years. So this is going to be an ongoing issue. I think from UTA's perspective as well, it's financial. They have relationships with a number of writers who were formerly their clients, who are very busy right now, and in theory could be paying the agency a lot of commissions. And so I think it was from that perspective, it was helpful for UTA to close and be able to start representing their clients again. That financial prerogative and issue is there for the other three agencies who haven't settled. And so there is pressure on them, I'm sure, to one degree or another, to try to bring this issue to a resolution. And there's a lot of pressure on the WGA because those three agencies historically represented a significant number of writers who have significant amount of clout, and they're not happy with this issue being unresolved. Some of them are very strongly in favor of the WGA's position, but others aren't. And so I think there's pressure on all sides to bring this to a conclusion. I think there's, for some, less tolerance of the issue at a time when the industry as a whole is so challenged by outside forces. And so it'd be interesting to see how this issue plays out in the next 3 to 6 months to a year. So that's it for me.
Well, that's fantastic. Really good. And I'm sure there'll be questions at the end. So remember, the topic is what every entertainment lawyer should know. So I'm going to go through a number of items, some of which are very basic, but may not be at the top of your thoughts. First one I'm going to talk about is Civil Code 1717. As you know, you don't get attorney's fees in a breach of contract case unless there's a clause that says that. And that's what 1717 is about. As a general rule, I want a prevailing party to get attorney's fees because I figure my client is going to be in the right. But I think you need to advise your clients the pros and cons that could happen. And I've seen so many times cases come in that were righteous that we didn't want to take because they're only worth a couple $100,000, and it's going to spend 6 figures to get into that particular case. So it may be attractive to counsel, particularly if you're representing the so-called little guy, to recommend that there be an attorney's fees clause. Secondly is venue. I cannot tell you how many times, including twice in the last week or two, I've had cases come in or been involved in cases where the venue is New York, or lately it was Vegas, and the parties are out here. But counsel in one situation who did the deal was based in New York, so they had New York law. I don't want to be in New York. I don't want to be hometown. And in other words, I don't want to have to go to some place and the lawyer knows the judge and hangs out and or in the country club or whatever else it may be. So be wary of that, and be wary when they're trying to. I've got a case right now where they want to set it in Minnesota. I'm sorry, but my client is out here. Leave it out if that's the way it's got to be, and we can, or you can say whoever wants to file first has to file in the other person's jurisdiction overall. The next thing, and this is really common, is arbitration. It's really taken off in the last 10, 15 years, and virtually every single contract in Hollywood right now provides for arbitration. But there's many other cases where arbitration is made a part of the agreement. And the question there is, you have to balance certain factors. First is cost. You got a case that's involved that's $50,000, you're going to spend $25,000 with an arbitrator and the costs of the administrator. So I think it's incumbent upon counsel doing deals to advise their clients on the pros and cons of attorney's fees clauses and of arbitration. You'll note that in the employment context, we have the Armendariz case going back 20 years, where the California Supreme Court said if you can't afford it and you're an employee, they got to pay. So that's another factor for employers to be thinking of. Do they want to have that possibility, in fact, probability? There is also a new discovery case that came down the 20th. What's the day? The 29th? 27th? So that's 7 days ago. The case is Axtron, AIXTRON, Inc. v. Vico from the 6th District Court of Appeal in Sacramento, which said there's no third-party discovery in arbitrations. How about that? So you may want to, or you should, put a provision in your agreement if you want that says we have the right to conduct third-party discovery. You agree. But otherwise, apparently that's the rule right now. One of the things you want to know is when I get an arbitrator, what's his history? If it's a net profits case or an employment case, how has he ruled in the past? Ordinarily, you're not going to get that information ever. You might want to consider having a judicial reference, which basically is arbitration, only it's supervised by the Superior Court and can go up through the Court of Appeal, et cetera. And in an arbitration, basically you cannot overturn it unless you can show that the arbitrator was biased, drunk, or utterly incompetent, or refused to hear legitimate evidence. It's very, very tough to get these thrown out. You're in a much better situation if you want to challenge an arbitration by having a reference, but one of the reasons you go to arbitration is to get finality and to get it over with. So that's another issue. One of the things you can do is say, well, look, let's pick the arbitrator right now, or the provider that we're going to use. And if we can't agree, then we will each hire a third party who will select such person. I want to note about AAA. Look, I'm sure AAA does great work overall, but they are alone in the fact that they have a filing fee based on the claim. And if you're making a claim for $1 million, they want something like $7,500 just as a fee on top of their other fees. So beware or careful about that as well. Do you want to have an arbitrator or require that he be or she be experienced in the entertainment industry? That's something you can put in. Do you want to have only retired judges? You can have that. Be careful that some agreements provide for 3 arbitrators. Well, if you got 3 arbitrators charging $700 an hour, that adds up quite quickly and may make it unfeasible overall. IFTA, the International Federation of Television, and I forget the rest of it, but they are the indie agency for disputes. They put on the 2 times a year the AFM selling conventions that are at the Lowe's Hotel in Santa Monica. But many, if not most, of the agreements with distributors provide that in the event of a dispute, you will go to an IFTA arbitration, where they have, and I'm in one right now, there's, I don't know, a dozen or so, they're all retired lawyers, or not retired lawyers, they're all lawyers experienced in the entertainment business, and they look like good panels. Yes, the International Film and Television Alliance, I've just been reminded, and they're efficient and they can do a good job. But the problem there is you're not allowed discovery unless the arbitrator says you can do it. So you may want to require that, say, I get to at least get documents or take a deposition or 2 or more. And that's another thing you can do in arbitration agreements, is limit the discovery, or say it's the same discovery as permitted under the Code of Civil Procedure. But one, I'm not going to call it a quirk, one thing to be wary of and is there's no fraud claims allowed and no punitive damages overall. That doesn't mean, and they say you can go file in the Superior Court, but you're going to have two claims. So it may be advisable to go do an if to claim, and then if it turns out that there's fraud, you go and pursue that if they've got the money in the Superior Court and try and get punitive damages. Arbitration clauses in attorney-client fee agreements. We're going to talk about fee agreements a little bit more, but I want to say that it is permissible to have an arbitration clause for disputes, any dispute between a lawyer and his client. That includes malpractice claims or claims over fees. I think lawyers generally do this. My experience is because they do not want their business on the street overall. It's bad PR. So consider doing that. Virtually every firm I know of does in fact do it. Next is you better have your fee agreements in writing overall. If you don't, you're only entitled to quantum merit, which can be hourly or the result achieved. But if you're on a percentage basis, and a lot of people say, I'll do it for 5% or 10%, then you need to have it in writing. And there was a big lawsuit, I'm going to say 12, 14 years ago with a big firm and a partner who left, who took the continuing payments from a couple big clients, and the court ruled, sorry, you didn't have it in writing. Client can go wherever the client wants to go. Do you want to have a lien for fees? Look, in all of our agreements where we're working contingency on litigation, we have a lien out of the recovery. And every lawyer does in personal injury as well. So you need to have that lien, and you need to put in the agreement, I'm advising you, you have the right to seek independent counsel with respect to this particular lien situation, and explain what the lien is. Query as to whether or not you can get a lien on contingent projects. In other words, I have been representing somebody who is a big director, and I've been doing it for a long time, and he fires me at the moment of truth. Can I assert a lien for at least my hourlies or a percentage on the money that he's going to get, the $1 million? The answer is, I haven't seen that in a case yet, but I don't see why not. If you're working contingency, how is it calculated? Can you get paid? Do you get paid hourly, based a minimum, or a reasonable fee based on results, or something in between? It can be done any way as long as it's not overreaching. Many contracts, this is bad out of fee agreements, many contracts, some waive punitive damages. Can that be done? There is a civil code section that says you cannot waive willful conduct ever. So does that apply to punitive damages? That was the issue in the Bones case. Where the trial judge threw out the arbitrator award of $120,000, $20 million or so, on the basis there was a no punitive damage clause. The answer is uncertain at this point. Also, what you see many times in cases or in claims is a waiver of punitive damages. So let's say you don't have to go to arbitration, but you're going to be in court. A waiver of jury trials. Do you want that? Of course, if you're the plaintiff, you always want to have a jury. So be careful of that. You need to know about class action waivers if you're representing entities or even an individual who might get hit with a class action. The rule of the Supreme Court is that class action waivers are permitted. However, a decision came down 7 days ago called Garner versus Interstate Oil Company. And there, the case said, you said that there's no class action litigation. Yeah, well, you have an arbitration clause, and it doesn't say there's no class action for arbitration. So you're going to have a class action in the Superior Court. So that means cross your T's and dot your I's. You cannot waive. There's another decision that came down 7 days ago, but which was reaffirming a previous decision. It says you cannot waive private attorney general right to sue claims. In other words, typically labor claims. And you can bring class actions for these overall, because the thought of the court was that this isn't between just you and some company. We have the government involved, the attorney general, and therefore, and you're enforcing the rights of the people. So don't put in any agreement that every single claim, including private attorney general claims, are going to go to arbitration, because it's not going to work. In your fee agreements with your clients, and I'm reminding you, if you have more than one client, you must get a conflict waiver. And if you don't, somebody's going to come after you down the line if things go awry. This includes individuals who have their own loan-out corporations and control it entirely. They're two different clients. It doesn't make perhaps intellectual sense, but it's a requirement overall. Also, in attorney fee agreements, do you want to have prevailing party fees? Well, remember, attorneys who are working on their own cases cannot charge for their rates in such situations. Therefore, it may be in the best interest of the attorney to say each side is going to bear his or her own costs. When it comes to movie deals, I want to mention separated rights. Separated rights are the rights under union agreements, typically the WGA, where the writer has the right to do novelizations and I've seen this happen in a stage play, a musical it was. And the client ultimately got the right to do the musical. And guess what? The studio said, you can't use the name of the show, because they still controlled that. So when you're negotiating for an artist, for a writer, you want to make sure that you get to do that. Next is writer agreements. I just had this come up the other day, where my client has written her third or fourth movie of the week, and they're giving her only teleplay by credit as opposed to written by. It's basically the same thing. She wrote the book, she wrote the script, but they are only going to give her teleplay. Why? Because it's a $10,000 difference on residuals overall if you have written by. So be aware of the value of credits overall. Audit rights. When I'm negotiating deals, or if I'm seeing them because I'm looking at a back-end situation, I want to get to the source of the revenue as soon as possible. Well, if I have a deal with a production company, ordinarily I have no right to go to the studio. Well, what can I see at least the audits or participate in the audit if you're going to audit the studio? I want to ensure that and put this in the agreement. I get the benefit of any audit. I had a case where a big musician settled a case for a lot of money, got a huge advance, and my client got nothing. We went after the musician saying, hey, you sold out my guy. So I want to know what's going on when you do it. It happens invariably that auditors are prohibited from discussing with other people they are auditing for on the same project. It's totally unfair, and it should not be permitted whatsoever. Then there's Windancer, which is a 2017 case, Windancer Production Group v. Walt Disney, which was horrible for talent, because it basically said, you got to audit or make a complaint, even if you don't know, if you just have a hunch, and file a lawsuit that you got taken advantage of. Well, movies and television shows typically are not going to earn out until 5 years down the line. And if unfair practices occurred with respect to deductions in the first year or the second year, that may ruin the entire future of getting revenues overall. For example, with interest that is charged on the production, which is outrageous, and you're supposed to object within that period. So maybe what you want to do is say, well, let's have you will continue to account to me for 5 years. What the agreements all say, after 2 years, we don't have to account to you anymore if we don't owe you money. Well, you should say, I want you to account to me for 5 years now. That's why this business that Scott was talking about of the new way in which deals are done by the streamers may be ultimately beneficial to talent, because they're going to give you your profit, win or lose.
I found it very difficult to get a incontestability period beyond 3 years. Sometimes you can get 3 years. I've never gotten 5. But what we do often when we don't get enough time to really understand where ultimately, whether it makes sense to audit or file a lawsuit, most of the studios are prepared at the time to give you a tolling agreement.
Right.
So you buy yourself some more time. And so you can end up in a position where you're, 5 years out before you actually have to make a decision. The other thing I would add and recommend is when you're helping a client to analyze whether or not it makes sense to audit, the auditors will, give you a pretty good sense of the value of your claim beforehand, before they, you have to hire them. And so they will give you some guidance and for free. And I recommend you get that, before you make any definitive decisions with your client.
Yeah, and audits aren't cheap. For the good auditors, you pay $50,000, $100,000 or even more. Okay, so the next issue is vertical integration. If you're negotiating a deal, you want to have arm's length value if it's with an affiliated company. Of course, it only makes sense, and this has been an issue for the last 2 decades overall. It was the big issue in the Bones case, et cetera. Now, you should not be able to have a problem with that. Another thing is that you should be negotiating in deals. If there is a new technology that comes in, we are going to get compensated. I have seen, I'm not going to say exactly how, but I've seen it argued that we didn't anticipate streaming, therefore you don't get anything whatsoever. And New York law is not particularly helpful to those claiming those kinds of rights. There's an argument that might in fact work.
Now, can I just interject there, because it was a point I had neglected to make in when I was speaking, but it's relevant to that point. You really have to be very careful in reviewing how the studio definitions define home entertainment versus VOD. You have a lot of studios now will broadly define home entertainment to include not just physical DVDs, not EST, but also all the VODs, TVOD, AVOD, and SVOD. And the way in which they calculate revenues from home entertainment is something you have to really focus on. So for instance, historically and to this day, physical DVDs are typically accounted for on a royalty basis. What the studios have tried to do in most definitions is to extend that royalty calculation into VOD, which makes no sense, because the reason why the royalty was used initially for home video was that there was great expense to manufacturing physical DVDs. I don't want to get into the whole history of that, but there was some rationale at the beginning. Now there's no rationale for it. And really what you have to try to do if you're on the participant side is to get all the VODs calculated at 100% of gross revenue, less whatever fees and costs are associated, as opposed to a 20 or 30 or 35% royalty. The differential in the numbers is significant. So it's an issue you really have to press as much as you can. So the definitions are very important.
Right. And so does somebody get paid on ad revenues? I've not seen that happen yet, but for ad-supported video, internet, that's something I would want if I'm a creator or producer overall. Collaborators. This works in music. This works in film. One of my first cases I did a long time ago was a songwriter who copped a melody, or allegedly, from another famous songwriter and got sued. And the lyricist said, what's going on here? I didn't have anything to do with this. And they could have both been tagged. It ultimately got resolved, but it wasn't the first time that happened. So you want to have a warranty of originality, ideally, by your collaborators. Don't forget about releases, 1542 Civil Code, that you're waiving all known and unknown claims. It's in virtually every agreement, settlement agreement that is done, and it ought to be in there overall, unless you want to specifically carve out something. But be aware of it. It's malpractice not to put it in.
Neville, can I ask you a question on that?
Yeah.
Do you put in the 1542 language even if you're dealing with an agreement that's not governed by California law?
Wow, I haven't thought about that before. If I have a California party, I sure would.
But if you don't, is it still safe to put, it makes sense to put it
I
in
don't
there?
see why not. How's it going to hurt you? I would presume that's the rule across the United States. Finally, or not finally, there's more coming. COVID waivers, assumption of the risk. I know that's been happening, and you know what? I don't think it's going to play at all whatsoever. I've seen in agreements before, if you're involved in a dangerous situation, you waive all of your rights. We're going to throw you out of an airplane. Well, if the parachute doesn't work, I'm sorry, I'm going to be able to sue all of the people responsible, generally speaking. David Albert Pierce is an entertainment lawyer. He's a friend of mine. I respect him. He gave me some information as well that he thought should be conveyed to everybody. And this is what he says. Transactional attorneys routinely draft contracts which are entirely unlawful or they have overreaching clauses. For example, they intentionally, we talked about this, misclassify employees as independent contractors. Okay. Producers routinely violate minimum wage and overtime provisions, particularly in reality TV. Producers took the notion that a contestant on The Price is Right is not an employee and expanded it to a show like Survivor. And they put in exclusivity provisions and substantial control, thus making them employees. And these aren't even contents. The shows that aren't even contents likewise treat their participants as documentary subjects, not employees. And that violates the law as well. They even draft covenants not to compete that go against California law. And then he writes, I believe when you couple the professional rule that requires a lawyer to be competent in the area that he or she practices, coupled with the new rule 4.1, truthfulness in statements to others, lawyers in reality producers and low-budget films are regularly drafting contracts that are violating the law. On another matter, he says, hey, production counsel, if you're not skilled in employment law, you shouldn't be drafting these agreements or using other people's forms without understanding if those terms comply with the law. And finally, he says in distribution agreements, he frequently sees counsel saying, I want a mortgage on the contract for the distributor. And he says, mortgage for what? How are you going to get a mortgage? Do you understand what a mortgage is? You cannot get a mortgage. If you advance the money, maybe you can get a mortgage overall, but please don't put that in there. So with that, I think we should go see what kind of questions we have here overall. And let's go through them. William Immerman writes, aren't waivers of COVID claims prohibited under California law? Well, I just talked about it. I think so. If anybody has a different viewpoint, let me know. We have another question. I have a client that is in a contract for production and the network exercised its option to move forward for the new season. My client is a new mother and doesn't want to travel every 2 weeks due to COVID, but she is contractually obligated to. I argued force majeure, but the network claimed exactly what you said. It's their right, not hers. Does she have any fallback with force majeure? Do I have an argument to present? Anybody want to take that?
Well, in the first instance, you definitely would want to call it's an actress, SAG-AFTRA, to understand what they know about the production, what protocols the production is taking, and that sort of thing. I have been in working with a network on a network reality show, and with certain contestants, we are looking at private travel and other travel arrangements with the view that we want to make sure that our participants are considered safe for their benefit, most importantly, but from ours as well, because obviously we don't want to bring someone to the set in an unsafe manner and then have an issue. So it's in everyone's interest to make sure that any travel, as well as the accommodations, while working at a remote location, are done in a safe manner. I think while I don't think they're probably right, force majeure is not something that you can enforce. It doesn't sound like, depending on how the contract is written. There are other avenues you can pursue to make sure that your client feels safe in proceeding.
So I've mentioned a couple points with respect to that. Is I'm in the process of negotiating a deal, and I said, hey, well, what's this force majeure stuff? I'm doing a deal right now. You're developing some rights, etc. Let's say it doesn't include this pandemic, and they go, no. If it gets worse, we're going to have force majeure. And then, as Scott adverted to, well, there was a 6-month or 1-year limit, I suppose, as to how far they can push it out. But that's an issue. Another issue is, let's say it's I'm the lead actor in the series comes down with COVID and can't perform anymore. Well, what happens to me? Do I have pay or play? Do I still get paid? What does my agreement say? Overall, I gave up working for somebody else to do that. That's something that would have to be negotiated overall.
Just to come back to the force majeure for 1 second, the other thing to be mindful of is that a lot of force majeure provisions say that you can only suspend for the same event one time. And so there's been a lot of discussion about, well, what if we were to unsuspend because we think we're going to go and then the government shuts us down again? Are we going to have to resuspend? And can we do that under the contract? And so, there's no easy answer there, but it's something you have to really carefully review as you go into that situation.
I was representing a festival right around the time that COVID was starting to break, and the agreements with talent that came from all the major talent agencies said, you are going to pay 100% of the money, and we get to keep the advance that was paid, even if it's a force majeure, if we're ready, willing, and able. And that, fortunately, my client was able to get out of all these situations, but you better be mindful of that as well if somebody wants to come after you. Okay, so...
By the way, one other aspect of that, in some of the touring agreements that I've done recently where there's been force majeure language, to protect the artist, I've put language in that says that if the deposit has been paid, that the recording artist has the right to deduct any of their out-of-pocket costs that are not refundable from the deposit if they have to give the remainder of the deposit back. So at least the artist is not out of pocket.
All right, here's another question for David. David, thanks for the informative opening. What are the implications of AB5 when it comes to studio recording artist relationship? Though studios, and the person says by studios, I mean the record label, can't technically own the copyright per the Copyright Act. They still do and arrange it as a work for hire. With the new law, are there additional challenges when it comes to a studio / or I guess record company recording artist copyright issues?
I mean, the record companies are going to continue to take the position that they're the owner of the work on a work made for hire basis. But every one of those recording contracts deemed you to be an independent contractor. We have to go back and look at the amended language from AB5. I do believe that it relates to recording artists as well, but I'd have to go back and check the revisions. I know songwriters were exempt. I believe recording artists were exempt as well, thinking that the scope of class of people to be protected by AB5 was not intended to cover recording artists, but you should definitely look carefully at the statute.
Right, and there's an issue with respect to work for hire for pre-78 masters, I believe, and for post. You couldn't get a copyright on a sound recording until 72 or so, and there's the record companies are saying now, because artists are asserting a reversionary rights because the 35 years is up, that they can't do it because they were works made for hire. Well, under the 78 Act or 76 Act, you had to meet certain requirements of payment and supervision, et cetera. And there's a class action going in New York right now against Sony on this particular issue, as I understand it. But for any of you people that are recording artists, you want to take a look at those contracts and then ask your client whether they were met the requirements of the Copyright Act. All right, the next question is, what's the most effective procedure to conduct mediations in the age of COVID? I'll answer that, and the answer is that we have mediations on Zoom now, and I've done 2 already. Or 3, they've been excellent, and that's what everybody is doing overall. So you can still have the mediations. The problem is that we don't have trial dates, and people working on contingency can't get to, they can't get a trial date. It's not going to just scare the defendant. I talked to a friend of mine who's a big personal injury lawyer, and he said he spoke with counsel who represents insurance companies. He said, I can settle any case under $25,000. Other than that, we're not settling any cases of any nature. They're just going to sit on their money.
I was in if I can just interject, I was actually deposed a couple months ago, and what I found interesting, and I've been through many mediations and depositions, and they've all been physical, and you usually take advantage of the fact that there are several conference rooms, so you can do breakout, you can move to another conference room to talk to your lawyer, et cetera, and what Zoom provides and other organizations is virtual breakout rooms. So it literally is seamless in terms of being able to have different rooms to speak different constituents.
Okay. In the mention of IFTA arbitrations, did you say fraud is not a recognized cause of action to bring in an arbitration? That is correct. In an IFTA arbitration, you cannot do it. We have another question. What sort of buyouts are you seeing on films, and how has the majeure definition changed for streamer deals?
Well, I'll try to tackle that. Buyouts are different ways it's done. Sometimes if it's a deal between a studio and a streamer, you will see buyouts that are negotiated as a percentage of the overall budget for the picture. When there are multiple buyout recipients, it tends to be more of a dollar-denominated amount. I think the streamers calculate what they think they project for the value of the buyout, and they make their offers based on that. And on the participant side, a participant needs to look at what they would have made at various levels of performance based on their precedential back-end participation, be it gross, adjusted gross, net profits. And so it's a negotiation in that light. In terms of the MAGR definitions, I don't think I've seen any. The key drivers remain the same. What is the distribution fee? What is it charged on? Is there an overhead charge? How is that calculated? In circumstances where there is an imputed license fee, that can be a huge negotiating issue or have a huge impact on the value of the MAGR participation.
Okay, for David, or for everybody, how does AB5 impact graphic designers, web developers, and fine artists, and fine artists such as those who do cover art? Are these independent contractors or not?
I wouldn't say it's entirely clear, but if you look at AB5, there is a set of guidelines in there for when you're determined to be an employee versus an independent contractor. So I would look. There's no specific reference to those classes of employees. So you have to look at the parameters.
Yeah, and there is criteria in the law and in common law as to what determines whether it's an independent contractor or not.
All right, we have David, what do you advise songwriters do with their 50% publisher share of successful songs after they've left a co-publishing deal?
Well, many publishing deals have what I call first right of refusal, last negotiation. So if you have a co-publishing deal, there's two issues that you need to be mindful of. One, does the co-owner of the copyright have the right to make the first offer to you or match the right if you try and sell it to a third party? And then the other issue, which people oftentimes overlook, but it's really critical, in many of the co-publishing agreements, there's exclusive administration rights. So when the term ends, make sure that the co-publishing agreement provides that the administration rights to your share of the publishing goes back to you. Otherwise, you're bound to be with them for the life of the copyright, even though you might not have intended that from the outset.
Right. I was negotiating that today for a songwriter on legacy songs, and the other side is very much trying to have exactly that kind of provision. And I'm going, why? You know? And do you know how hard it is to go through this business of I'll do a first negotiation, but a right to match
Right.
is such a pain. I've never actually seen it happen in all the years I've been practicing. Have
And
you?
keep the time frame short. Most people will say 30 or 60 days. If I agree to the provision at all, I won't give them more than 10 days on a matching rate.
We have another interesting question. I've read the Australian government has announced a fund to cover COVID-related claims since insurance companies won't insure these. Can you talk about this? And are there any other government relief? Is there any other government relief out there? I'm not aware of any. It's been talked about.
I have heard about that in the province of Quebec has instituted something similar to that. I wasn't aware of Australia, so that's news. Thank you for that information. I think you're seeing that the insurance market is just not prepared to enter these claims. There's just, there's just not an appetite in the reinsurance market for it. And so governments are going to have to step in, not dissimilar to what they did after 9/11 in certain circumstances. So you may see more of this. You could even in theory see it on a state-by-state level. I haven't seen any of it in the United States or any individual state yet, but you might see that in the future.
Yeah, I wrote an article for the Daily Journal a couple of weeks ago about COVID and production, and learned that in agreeing with Scott, there's no insurance you can get for COVID right now. A couple of insurance companies may give you up to 10 or 20% of your budget, but they have a very high premium for that overall. And so what it really comes down to is this: if you have a low budget movie, $1 million or so, you may want to just go ahead without any insurance. If you got a $10 million indie film and your lead actor or the director gets sick, you got a really big problem. And
well, you can't get financing is one of the problems. Even if you're prepared to self-insure, unless you have a credit-worthy, backstop or backer, truly independent movie can't go forward now because you can't buy the full range of insurance in a bond that covers the full range of claims.
Right, and pre-sale deals are not going to happen because no distributor is going to guarantee in such a situation.
Well,
ever.
No bank is going to will lend credit to a pre-sale contract that requires that the delivery happen by a certain date, because they have no idea if there's going to be a COVID delay, and therefore there's no bond to support that. So the whole structure unravels until there's, insurance support for this.
Right.
We actually have two more questions. We're going to go over the allotted time just so we can give everybody an extra round.
We can go over time.
Question regarding 8.4 misconduct. Rule 8.4 prohibits a lawyer to engage in fraud/misrepresentation, but comment 6 says 8.4, this rule does not prohibit those activities of a particular lawyer that are protected by the First Amendment of the United States and the California Constitution. How should we understand comment 6? I'm sorry, but you can't commit fraud and claim the First Amendment, in my opinion. Anybody have any different thought? Okay, the last question is similar to the question about record labels and sound recordings. Because a sound recording cannot be a work made for hire under the copyright code, is there any way for a podcast network studio to own the audio files created by their talent without making them employees and thus automatically owned by the ER, whatever that means, in California? So you guys understand that?
Well, first of all, a sound recording can be a work made for hire under the Copyright Act. So I'm not sure where that premise came from, but I think it's, one subject to negotiation. I think oftentimes in these virtual concerts, I know that when I'm representing the recording artist, I will allow the platform to participate in the revenue stream, but I want the copyright to revert back to the artist so that the artist can then repurpose that content for any things that they want in the future. And so I don't want to be encumbered by any work made for hire language, but I think it's a negotiation.
I would mention in a podcast or interview situation, somebody may own the copyright, but I think there's an argument that if I'm being interviewed on a podcast, I'm an equal owner in the copyright of what I've said overall, unless there's something to the contrary. So you might want to be thinking about that as podcast takes over our world.
Yep.
I have to leave now because I have to go listen to a podcast.
Make sure you get a release.
Yeah.
All right. So you two guys, you're fantastic. I'm sure we had a big crowd, 150 people at least. And I hope it was valuable to all of you. And join the Beverly Hills Bar Association. Thanks a lot.
All right,
Thank you,
everybody.
Neville. Thanks, everyone. Thanks,
Be
David.
safe.